Well, today, the Supreme Court heard 90 minutes of arguments that could impact hundreds of defendants, all in the riot at the U.S. Capitol, and even a case that involves former President Trump. As Christian Benavides explains, at issue is the statute that came out of the Enron scandal that the government has been using to charge those defendants with felony obstruction.
The U.S. Supreme Court is considering whether federal prosecutors correctly charged more than 350 people at the January 6th Capitol riot with felony obstruction of an official proceeding. That includes former Harrisburg, Pennsylvania police officer Joseph Fisher, who petitioned the High Court. His lawyer argued the government is using the obstruction statute as a dragnet.
Until the January 6th prosecutions, Section 1512C2, the otherwise provision, had never been used to prosecute anything other than evidence tampering.
The U.S. Solicitor General told the court there's no question Fisher and other defendants obstructed the process to count electoral votes.
Yes, he obstructed that official proceeding. The terms of the statute unambiguously encompass his conduct.
Justices probed the scope of the statute and if it could be used to criminalize other types of conduct.
Would a sit-in that disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify, or at the State of the Union address? Would pulling a fire alarm before a vote qualify for 20 years in federal prison?
More than 100 January 6th rioters were convicted under this law. If the court sides with Fisher, it could lead to new trials or lighter sentences. Former President Donald Trump faces the same obstruction charge in special counsel Jack Smith's upcoming election subversion case. Christian Benavides, CBS News, Washington.